Thank you all for coming. My name is RJ Simpson. I'm the president of the Aboriginal Law Students Association, and we're the ones who put this on every year. First, I'd like to acknowledge that we're on Treaty 6 territory, and I'd like to thank all the members of Treaty 6 for attending. And as our Professor Kathy Bell always likes to point out, whether you're represented by a First Nation or the Government of Canada, we're all treaty people. I'd like to acknowledge one of our speakers who isn't here yet, but he's attending the event all week, Chief Justice Emeritus of the Supreme Court of the Navajo Nation, Robert Yazzie. We've been honored to have him all week. He's been sharing his knowledge with us, and he'll be speaking here tomorrow. I'd like to thank all the other elders who made it here today. And finally, I'd like to thank the Faculty of Law for providing this space for us. They're very generous every year with that. And I'd like to thank AFCO Group and the Alberta Law Foundation for their generous financial support. So every year, we choose a different topic for the week. This year's topic is Aboriginals and the criminal justice system. And we bring in 5 speakers. Today's speaker is Jonathan Rudin. He's the program director of the Aboriginal Legal Services of Toronto. He received his law degree and his master's degree from Osgoode Hall. 24 years ago, he was hired to establish the Aboriginal Legal Services of Toronto, and he's been there ever since. He's appeared before all levels of court, including the Supreme Court. He helped establish the first Aboriginal Justice Program in Canada in 1992, and in 2001 he helped establish the Gladue courts at the Old City Hall courts in Toronto. He co-wrote the Royal Commission on Aboriginal People's Report on Justice. He was a member of the Research and Advisory Committee for the Overwatch Committee for Inquiry, and he teaches part-time at the Law and Society program at York University. The past 2 days, both speakers have referenced his work extensively, so he's a big deal in the world of Aboriginal criminal law. And we got to have dinner with him last night, and so I can also say he's a pretty nice guy. So let's give a hand to Jonathan Rudin. Thank you.
Hi everyone, thank you RJ. Just one correction, it wasn't the first Aboriginal Justice Program, I don't want to take things away from it. The first urban Aboriginal Justice Program, and to be fair about that, we started about the same time as the Tuan Lin Dun program started in Whitehorse. So Whitehorse is an urban area too, 13,000 people at the time, so I don't want to take credit for that, but so anyway, I'm very honored to be here. RJ sent me the list of speakers, and it's an incredible list. So I'm very honored to be with them. I know many of them, and Justice Yazzie, although I met him last night, I read his work for many years. So I'm very, very happy to be here. I want to start by talking about something that happened when Jamie Gladue was sentenced. Not at the Supreme Court of Canada, not in 1999. This happened in 1997. A couple things happened when she was sentenced that I think are quite significant, but it might just be me. So you'll have to see, but it could just be me. So it's 1997. Jamie Gladue has pled guilty to manslaughter. There's this new section in the criminal code that no one knows what it means, section 718.2e. And it says that judges should look for all alternatives to incarceration for everyone, and then it says with particular attention to the circumstances of Aboriginal people. And no one knows what this means. No one in the courtroom knows what it means. Everyone's just kind of making it up. Because we don't actually know what anything means till the Supreme Court tells us, and they don't tell us till 1999. But there's this moment, just a very brief moment, where Jamie Gladue's lawyer, not the lawyer who represented her on her appeals, but her trial lawyer, is talking to the judge about her. And he's mentioned that she is Cree and Métis, and he mentions that she's from Alberta. In fact, she's from McLennan, Alberta, but I have no idea where that is. Where is McLennan? Does anyone know where McLennan, Alberta is? Yes? Okay, thank you. So he says she's from McLennan, Alberta. And then there is this, it's not even a moment. The judge says, is that an Aboriginal community? The lawyer says, no, it's a regular community. And then they keep going. Now, I think that's an incredibly significant moment. second. I think it's incredibly significant. Is this an Aboriginal community? No, it's a regular community. Now, what can that possibly mean? It makes, on one hand, it makes absolutely no sense, right? What do you mean it's a regular community? If you actually had stopped, if you were able to press pause in the court at that moment, or someone was able to stand up and say, excuse me, what do you mean by a regular community? People would have said, oh, no, just kind of a non-Aboriginal. People would kind of make up what it means. But everybody, I think you all know what's meant when someone says it's a regular community, in contrast to is it an Aboriginal? There's a huge amount of information that was transferred in those 5 seconds between the lawyer and the judge. They didn't have to explain it. No one had to say what they meant because they knew. They knew exactly what they meant. Each of them had pictures in their head of what an Aboriginal community is. They know what a regular community is, and they knew all those things. And all that information passed like that. That's the reality. That's the reality that Aboriginal people face and that lawyers representing Aboriginal people face every day when they're in court. It's not that people don't know anything about Aboriginal. They think they know a lot about Aboriginal. And what they know is so deeply ingrained, so much a part of them, that it doesn't have to be spoken. You can just say meaningless words, like it's a regular community, and people get it. Maybe the Aboriginal person doesn't quite get it. What do you mean? But everyone else gets it. The important people, meaning the people who get to make the decision, they get it. So that's I think, a really important thing to keep in mind. The other interesting thing that happened, that I find very significant, that happened when Jamie Gladue was being sentenced, was when the judge finally decided to sentence her. So he's got this section that says you have to look at the circumstances of Aboriginal people. He knows she's an Aboriginal person because he knows that she is Métis and Cree. So he knows all those things. And he's looking at her. He's sentencing her, and he's looking at her, and he says, and I'm paraphrasing, but he says, the section 718(2)E says that it applies to all Aboriginal people, but you're not living in an Aboriginal community. And so there's nothing specifically Aboriginal about this, so I'm not going to take this section into account. And he decides not to. Now, Supreme Court reverses this. But again, this is fascinating. Here's a guy, he's a lawyer, he's a judge. He is sentencing an Aboriginal person. He has before him an Aboriginal person, and yet he's able, at this moment, you're not an Aboriginal person to me. I will tell you who's an Aboriginal person, and you're not. Now, not trying to be nasty, I'm sure. I was Saskatoon in about 2000. I was at a conference, I was talking about Gladue, and I was on an elevator, and some people got on the elevator from British Columbia, and they made a point of telling me that the judge who sentenced Jamie Gladue was a really nice guy, and he wasn't a racist and all that, and I believe them completely. I have no reason to doubt them, and that's why this is even more significant. I don't think the judge who sentenced Jamie Gladue was a racist, but he was able to look at her and say, you're not an Aboriginal person because you don't live in an Aboriginal community. This is Nanaimo. She had gone, and he knew this because this was before him, she had taken programming at the Native Friendship Center. There was a Native court worker who was there with her, but somehow that wasn't a Native community. Why? Because it didn't fit his picture of what an Aboriginal community should be. And so he was perfectly fine with saying, you're not an Aboriginal person. I can say that because I'm the judge and you don't fit my perception of who an Aboriginal person is. And that is very much the reality, was the reality then, and is still very much the reality now, when Aboriginal people come before the criminal justice system. People have assumptions. They have beliefs. They have long-held opinions, stereotypes, call it what you will, about Aboriginal people. And they are firmly embedded in their heads. And you have to deal with that if you're representing someone, a person before the court. You have to deal with that. Assumptions are incredibly powerful. They are incredibly powerful. And they're so powerful because they are unstated. See, it's easy if someone says, an Aboriginal person, I don't know anything about Aboriginal people. Tell me something about Aboriginal people. That would be easy. Because then you have a blank slate. Then you have someone who's willing to know. But in Canada, generally, when you come before a court, you are not dealing with a blank slate. You are dealing with someone, or everyone you're dealing with in the court, crowns, lawyers, judges, they all have opinions. They all have beliefs about Aboriginal people. And those beliefs and opinions are formed in many different places. Sometimes in the court, but sometimes in other places. And that's the reality that you deal with. I'm very fortunate in my work. I get to travel around. I get to come to Edmonton. Looks nice. Can't tell you how jealous people were. Wow, Edmonton in March. Yeah, and I was here in December too, because I know how to have a good time. But I have managed to travel. I've been to every province and territory in Canada, with the exception of Newfoundland and Labrador, as part of my work, and that's been great. That's really great. And I learned things when I traveled, including I learned things about myself. One of the things that I learned about myself, and I didn't know this, was that in Ontario, the further north I go, the stupider I get. Now, I didn't know this, right? I was not aware, because I thought I was still the same person. I didn't know that I got stupider the further north that I got. Fortunately, there were people who could tell me that I was getting stupider. And those people were judges and lawyers and crown attorneys. And they were not shy, the further north I got, to tell me how stupid I had become. And the reason that I had become stupid was that when I was going into northern Ontario, Thunder Bay, which is in northern Ontario, I would go and I would talk about Gladue, or just so you know, from Manitoba west it's Gladue, but from Ontario east it's Gladue. There's just so I try, since I'm here, and this is where Jamie Gladue is from, I try and respect her, and so I say Gladue, but then when I'm talking about Ontario and Quebec, I slip into Gladue because, anyway, you'll forgive me for that. So I go up to Thunder Bay and I say, hey, you know, this Gladue thing is really important, you should do something, and people tell me I'm stupid. We don't need this Gladue stuff. We don't need it here. People sometimes say it nicer, sometimes they say it even more directly. We don't need judges from Ottawa, judges from the Court of Appeal in Toronto telling us how to sentence Aboriginal. Because we've been sentencing Aboriginal people for a long time. We know these people, right? We know these people. So the judge will say, you know, I sentenced this guy, I sentenced his brothers, I've sentenced everyone in his family, and the Crown will say, you know, I sentenced him and I sentenced his wife, and defense counsel say, I represented him and his son and his grandfather. So they tell me that I don't know what I'm talking about because they don't need this Gladue stuff, because they know the community. They know the people they're dealing with. Now that's not something that I can respond to. And I can't say you don't. I don't know what people know, and I don't know what people don't know. I can't know that. But when I travel, I don't just hang out with judges and lawyers, as much fun as that is. I also try and spend time with Aboriginal court workers. I try and spend time with chiefs, with justice people from political and territorial organizations. I try and spend time with lots of different people. So when I'm in Northern Ontario, or wherever I go, I say to people, not judges and lawyers, but people from community, I say, so do you think that the judges and the lawyers who come into your community, because sometimes, certainly in Ontario, they fly in. There are these remote communities where the plane comes and the people come and the judges come in and the lawyers come in and they leave, sometimes with people in the plane who are going to jail, sometimes not. Sometimes it's an urban center like Thunder Bay. Anyway, I say to people, do you think that the people who come into your community or who are in your community and are doing justice, do they understand your community? Do you think they understand you? And not universal, but almost all the time what I hear is, these people don't really have a clue. Now, you have the judges and the lawyers thinking they know these communities really well. You have the members of the community thinking they don't know the community at all. I don't know what the answer to that. Like, I don't know who's right. Again, it's not my world. I can't say who's right or who's wrong. But what I can say is that's a pretty serious disconnect. That's a pretty serious disconnect. And what makes that disconnect even more serious is that while you have two sets of people who have very different opinions on what they know, one group, the judges and lawyers, have a huge amount of power. The other group generally have that power done to them. And so that's really serious. Because not knowing something is fine. I think it's, there are many things I don't know, there are many things that we don't know. Not knowing things is fine. But not knowing that you don't know something, that's a problem. The problem is when you think you know things and you don't. And I think too often what we see when Aboriginal people come before the criminal courts in this country is people think they know things, but they don't. And that's a serious issue. Because it's not just that you have to tell people things. It's not that they just have to learn things. It's in some ways they have to unlearn things. And that's where the challenge comes. If you tell someone, you say to a judge or a lawyer, there's an Aboriginal person coming into court. Next client's going to be an Aboriginal person. For the most part, people are immediate, and there's nothing wrong with this, we all do this. People are going to have a picture in their head. Oh, an Aboriginal person's coming to my court. And they're all going to get a little picture in their head of who's going to walk in the door. We all do that. What happens is, the more that person who walks in the door fits the picture in our head, the more they're an Aboriginal person. The less they fit that picture in the head, the easier it is for someone to say, you're not an Aboriginal person. So in Ontario, the Ontario example I like to give, if I say an Aboriginal person is coming into court, most people will sort of get this picture. They think, okay, it's going to be someone kind of brown, dark hair, preferably in a braid or a ponytail. Powwow t-shirt would be good. It'd be really great if their name was Big Canoe, because then we have no trouble at all knowing they're an Aboriginal person. Now, I've often given that example, and the legal advocacy director now at Aboriginal Legal Services is named Big Canoe, so she thinks it's hilarious. But actually, she talks about the fact that Krista Big Canoe, who's our advocacy director, Krista is, her skin coloring is fairly light. She's pretty pale. And she actually sees people sometimes trying to figure out, how can you be Big Canoe? Because you don't fit my picture of what someone who is Big Canoe is supposed to be. And so this is the reality. Again, the reality isn't someone go, oh, an Aboriginal person, tell me something about you. It's people are already thinking, well, you can't really be an Aboriginal person because you're not really fitting into my picture of what an Aboriginal person should be. And everybody does it. Aboriginal people do it too. Okay? Everybody does it. Doesn't make it right, but we all do it. What that means is, in the context of criminal law, I'll direct much of my comments to judges and crowns and lawyers, but you know, everyone, whenever you're representing or working with Aboriginal people, you need to confront your own sense of those issues too. Identity is a very, 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 very complicated thing for anyone. Aboriginal identity is complicated times 4,000. Because it's not only what you think. I mean, identity is complicated because we have to, all of us struggle with how we identify ourselves. And that's a challenge. But Aboriginal identity is particularly complicated in Canada because the Canadian government has for a long time believed that it's their responsibility to tell people who is or who is not an Aboriginal. And because we're so used in Canada, people in power are so used to being able to say, you are or you're not Aboriginal, it's easy for judges to fall into that too. So it's easy for the judge who was sentencing Jamie Gladue to say, yeah, nah, you're not really Aboriginal. You're not Aboriginal today. You're not Aboriginal today, you're not Aboriginal in this court. Maybe in another place, in another time, you'll be an Aboriginal person, but you're not an Aboriginal person to me today, and what counts is what I think. So this is a reality that we need to be aware of. So the challenge becomes, how do you try to confront that reality? How do you address that? The Supreme Court of Canada in the Gladue decision and in the Ipealy decision both said that judges can take judicial notice of the circumstances of Aboriginal people, which is an incredibly significant statement. You know, normally judicial notice is, yeah, the sun rises in the east and sets in the west. You can take judicial notice of that. You take judicial notice of the fact that there's a leap year every year that divides by 4 in February, unless it's the millennium year. Anyway, you can take judicial notice of that, if I got that right. But how do you take judicial notice of the circumstances of Aboriginal people? I mean, it's great if you know what those circumstances are. But how do you know? Where do you get that information? Let me give you two. We had 2 cases. I was involved in a case. It was a charter challenge and equality challenge. We're alleging that mandatory minimum sentences violate the equality rights of Aboriginal people. I still think we're right. 2 judges have said we're wrong, but I still think we're right. Anyway, we're talking, and we got all this expert testimony. We're in like day 2 or 3 of expert testimony, and this judge, very again, nice person. We're talking about colonialism, and she says, "What's this? What's colonialism?" I know you think, huh? I was talking. We had a delegation of people from Vietnam came to visit our office, and I told them the story. They know colonialism, right? I mean, when I say a judge didn't know what colonialism was, it was translated, so it took a while, but you could hear them all laughing after. Really, you didn't know what colonialism? She didn't know. Kind of a ripple thing. She didn't know what colonialism was. This was a case involving Haudenosaunee man. She asked. I'm glad she asked. She said, "So are all Aboriginal people Haudenosaunee?" Please. Just saying what she said. She didn't know. She didn't. And why would she? Why would she know anything? Right? Why would we expect that? We did a Gladue report. I'm going to talk a bit more about Gladue reports. We did a Gladue report for a couple men in a place outside of Toronto, west of Toronto. And we got a letter from the judge. We don't normally get letters from judges. We got a letter from the judge thanking us for the Gladue report. And, blah, 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 thank you for the Gladue report. He said, I learned a lot. I'm an Anglican, he wrote. I thought, well, thank you for for sharing. I hadn't asked, but he said, I'm an Anglican, and we talk about residential school in church. Because the Anglican church, among the churches, they actually do talk about some of their role in residential school. Not all the churches do. But the Anglican church, I guess, I've never been, but I guess at least his church talked about residential school. He had now, in this case, this was a case involving someone whose parents and grandparents had gone to residential school. So we talked in the Gladue report about intergenerational trauma in residential school. And so he wrote, I'd never heard of that. So he thanked us for telling him about intergenerational trauma in residential school because he'd never heard of it. And what he learned about Aboriginal people, he learned in church, which that can be that's a scary thing just generally. I mean, but in this case, the Anglican church, I'm sure they were doing a lot of good things, but that's where he learned. I mean, here at this university, we were talking last night, there are 2 Aboriginal courses, right? So when I went to law school a little while ago, there was 1 Aboriginal course. It was an elective. You know, there were like 20 of us in the class. You can easily go through law school and learn nothing about Aboriginal people. You can learn nothing about Aboriginal people in your criminal law class. You can learn nothing about Aboriginal people in your sentencing class. You don't have to learn anything about Aboriginal people. Then when you become a lawyer, you can learn, there's no requirement you learn anything about Aboriginal. In Ontario, the Ontario Legal Aid Plan has just started. It's an interesting idea. They now require, if you're going to represent an Aboriginal person and receive legal aid, you have to belong to what they call their Gladue panel, which requires you to have requires you to say that you've read a couple of decisions. The bar is not set very high yet, but anyway, they're at least talking about it. But you don't have to know anything about the circumstances of Aboriginal people to be a lawyer. You don't need to learn anything to be a judge. You don't get any specific training about that when you're a judge either. You can. I'm going, because I love the winter, after today I'm going to Winnipeg for tomorrow because it's not cold enough here. And there's a conference, a National Judicial Institute. So judges, particularly Superior Court judges, are going to be meeting, and they're having a whole few days about Gladue, and they're having or about Aboriginal people in the law, and they're having an afternoon. Some judges are going to talk about Aboriginal people and criminal justice and Gladue and appealing. But you don't have to know any of those things. So you never have to know these things. So where do people get the information? They get it, it's like wherever you get it. Maybe they watch Dances with Wolves. Which, if that's going to get it from somewhere, that's, I guess, get a nice warm and fuzzy feeling. Haven't seen it for a while. But where do people get this information? But they get it, right? There's no one in Canada who doesn't know anything about Aboriginal. No one. I've had some fascinating discussions in cabs with cab drivers about Aboriginal people. And they're really interesting to talk to, many of them, especially in Toronto. Because in Toronto, most cab drivers, not all, but most cab drivers are fairly new to the country. So what they know about Aboriginal people is what they hear on whatever radio station they listen to and whatever people get in their cab with. And so generally what they know is completely wrong. It's like completely wrong. But they say it with complete, because they're cab drivers, and you have to learn to speak with authority when you're a cab driver. But they say it with complete authority. Oh yeah, Indians, they don't have to pay any taxes, they get their free education, they get they just, all this stuff, and the pensions in the capital. Wait till we stop. But this is the reality. It's not that people don't know, it's that they have all sorts of stuff in their heads, much of which is wrong. Much of which is wrong. About telling people, getting that information to people about what they need to know. The Gladue and Ikeli decisions, and Section 718(2)E, say that judges need to understand the circumstances of Aboriginal people. They need to understand both the personal circumstances of the individual and the broader systemic issues that brought the person before the court. Now, we've been doing Gladue reports in Toronto, in Ontario, since 2001, I guess, 2001, 2002. So we've done about 1,000 of them or more. There are very few individuals that we interview. And we talk, say, tell us a bit about your life. Very few, not there are some, but very few sit down and say, you know, I think the root cause of my problem is that I'm the product of intergenerational trauma brought about by a colonialist attitude by the Canadian government to destroy Aboriginal people as a people, as exemplified in part, but not totally, by the residential school experience, and now witnessed by what was then the 60 scoop and now the millennial scoop. We have very few people who say that, right? Very few, which is not surprising, because they're living in the midst of the trauma that they're living in. In fact, when we ask most people, what was your childhood like? Do you know what they say? They say, it was okay. You know why they say that? Because it was okay. Because okay is a completely relational term. Okay means this is what I experienced compared to everyone around me, what they experienced. So if I say to you, my childhood was okay, you all go. That's you got no other place to go. You all go to your place in your head where what an okay childhood is. That's where you go, because where else can you go? The reality is that the experiences of not all, obviously, but many Aboriginal people, particularly many Aboriginal people before the courts, their world is so completely incomprehensible to judges and lawyers that they can't. Okay just gets them in a completely different place. They don't understand. How could they understand? How would they understand the lives that the people they're sentencing are experiencing? And the other challenge, and I'm now going to, I wasn't sure I'm going to do this, but I'm going to do this. So, the other challenge is that in the criminal justice system, it moves very fast. The criminal justice system moves very quickly. It was described to me by a Court of Appeal judge as a sausage factory. And it is. It's a sausage factory. It goes like that. Judges often are reviewed by senior judges how quickly can they do a sentence. You can do a sentencing. I sometimes say, you know, you can get a sentencing done in 15 minutes, but usually most judges tell me 15 minutes is way too slow. They can get a sentencing done from start to finish in much less time. And the reality is that in the sentencing process, what we don't know about someone, we don't have time to find out, we fill in the gaps. So most Aboriginal people, most everyone, but certainly most Aboriginal people who are being sentenced are represented in court by two pieces of paper. One piece of paper is the synopsis of the offense that they likely will have pled to, because most people plead. In Toronto, the synopsis is written by the police. It is generally grammatically incorrect, full of spelling errors, and also has a number of factual errors in them as well. But that's the one. And the other piece of paper is the person's prior criminal record. And if you've ever been to court, after someone has pleads guilty or is found guilty, the Crown is asked for their position on sentence. And the Crown, who often has never met the individual in their life, takes two pieces of paper, and because this is all they've got, constructs a whole world out of that person. Your Honor will have read the circumstances of the offense, This person clearly no regard for the victim in this matter, callous, etc., etc. And then, and Your Honor will see the prior criminal record. You will see 6 failed to appear and failed to comply. It's quite clear this individual has no interest whatsoever in following the decisions of the court. They're incorrigible. They can't learn. Last time they were here on a similar offense, they got 18 months. Clearly, we have to send a stronger lesson. I'm saying, you know, we have to send it to the pen or whatever. Maybe if I'm feeling nice, it'll be 19 months or it's 27. This is constructed because what do they know? They don't know anything. And then it's defense counsel's turn. And, you know, I don't want to be too hard on Crowns. And there are some really great Crowns, okay? And there are also really great defense counsel. But there are a lot of defense counsels who know nothing about their clients. Your Honor, my client is 24 years old. There's a term, it's called the swivel head defense submission. Sensitive. Your Honor, my client has a job in Toronto, the job everyone has, pretty much all the guys have anyway when they get out, they're all going to be roofers. They all have jobs as roofers. See, that's funny till you have to have your roof done. See, I had to have my roof done a few years ago. And the company came to do the roof and they said, you can go. I went, no, I can't. Because, you know, I'm sure they're all nice guys, but I know where they were before they came to work for you. So what's the judge supposed to do? The judge has no information. And so the judge ends up sentencing based on the little they have. And the assumptions they make about the person who's before them that they bring in when the person's an Aboriginal. They bring those in. Those assumptions take all sorts of forms. I often see, Gladue has often been reduced, tragically, unfortunately, been reduced to a checklist. Did you go to residential school? No? Oh, no. You know, did you grow up on the reserve? No. And you actually have judges in this province, many provinces, say, well, you know, I didn't grow up on the reserve, grew up in the city, middle class sort of environment, you're not really, you have no Aboriginal factors, nothing's impacted. Right? Because to be an Aboriginal person, you have to fit these assumptions. So often we've had to deal with the fact that someone that we work with was adopted when they were 6 months, raised in a non-Aboriginal home. Judge thinks, they try and find ways of saying it, right? But they think, well, look, you're adopted at 6 months, raised in a non-Aboriginal home. You know, without saying it, you're not really an Aboriginal person, right? So this is the problem, that people don't understand, that the fact that Aboriginal people are over at least 40% of children in care, that there are more children in care in CAS care in Canada at this moment than were ever at any one time in residential school. Though that reality, courts don't know that. And so if people don't have information, they don't look for it because they don't have time. They don't look for it because they don't think they need to, because they think they know it. They go back to the places that they learned whatever it is they learned. And so the challenge that we face in the work we do, and the challenge that you will face if you decide to do criminal law or whatever you decide to do in the criminal justice context, is how do you get information before the judge? How do you get that information before the judge so that this person stops being a caricature and a stereotype but becomes a real person? The way we do it, you know, with our staff is we write these things called Gladue reports. And checking the time, there will be time for questions. And the idea of the Gladue report is to tell the story of the person. So what our reports do is they tell the person's story. And they tell that person's story as much as possible in their own words. I don't know if any of you have read a pre-sentence report. Pre-sentence reports are written to a particular formula by probation officers. For the most part, I'll speak to the Ontario pre-sentence reports that I've seen. Pre-sentence reports look like they've been written by a machine. They all seem the same. But I also feel when I read a pre-sentence report, I learn more about the person who wrote the pre-sentence report than about the person who's the subject of the pre-sentence report. The pre-sentence report is a series of conclusions the person has arrived at about the person, but you never really know how they arrived at those conclusions. Pre-sentence reports are often based on risk assessment tools. Risk assessments have two aspects to them. There's the dynamic aspects and the static aspects. Static aspects are your sort of life experiences. Basically, if you're an Aboriginal person, you're at high risk to reoffend even if you've never done it. Because you're an Aboriginal person, which means you likely know someone who's been in trouble with the law, etc., etc., etc. Everyone at our office is at high, all the Aboriginal staff at our office, which is almost all our office, is at high risk to reoffend, even though they've never offended. We did an appeal for a guy who was 28, no priors, and he was found high risk to reoffend. Well, he's 28, he has no priors, he was, he's 18 to 28, 10 years, he didn't commit offense. How can he be high risk to reoffend when he's already at 10 years where he hasn't offended? Doesn't matter. That doesn't count because he probably, no one says it, but he probably was offending a whole bunch of times beforehand anyway. So that's what pre-sentence reports do. So what we try and do is tell people's story, and we try and tell the story. The best way to tell someone's story is to let people tell their own story. So our Gladue reports tell the person's story. The story doesn't start with them. Your story, your story, your story. None of our stories start with us, as much as we think they should. As much as the world really should revolve around all of us, individually, because it's really all about us. Our stories don't start with us. They start with decisions that were made by our parents, by our grandparents, by our great-grandparents. Decisions that were made for our parents, our grandparents, and our great-grandparents, by people who had the power to make those decisions. That's where our stories start. We can't we don't have to understand how we got to where we are, but if we want the court to understand how someone got to where they are, you need to start there. Our Gladue reports sometimes they run, the average of 20, 25 pages. Sometimes the subject of the report doesn't actually show up till page 11 or 12. Because you can't know their life until you know their parents' life, until you know their grandparents' life. Until you understand that grandma went to residential school, wasn't able to care for her daughter, and they had the child, etc. You can't know these things. You can't know these things till you know that. You can't know why we did a Gladue report for an Inuit man from Nunavut. His story, effectively in the modern world, started with the forced relocation of the Inuit off the land to the harbor communities, which was forced on them by the government because it was easier to look after them by bringing books. But that brought the dysfunction. If you asked him, he barely remembered. He actually was old enough to know when it happened, but he barely remembers it. He wouldn't put his finger on that for dysfunction, but that's where it happened. So as much as possible, first we go to the sources and we ask people to tell their stories, and we have them tell their stories in their own words. So the Gladue reports, as much as possible, are people telling their stories. Now, their stories aren't always the same. Our stories are not always the same. I have two younger brothers. In my story, I'm the greatest older brother they ever could have had. In their story, they make up these events where I locked them in the basement or something, which clearly didn't happen, because I would have remembered it. But they seem to have these false memories that they're holding on to really hard. So it's not about trying to tell people the truth about what happened, because we don't know. I can't tell you what happened to someone else's life. I can barely tell you what happened in my life, and all I can tell you in my life is what I remember about what happened in my life. I've been talking to my mother recently, and she reminds me of an event that was very significant. I had a talk with her when I was in high school. I don't remember this at all. She remembers it. So I don't know. I can only tell you my life as I know it. So we try and get as many different perspectives on the person's life and have them speak, and have their mother speak. Their mother speak and their father speak, so that they become real people. So that when the judge is reading it, this person that they're going to sentence becomes a person. And we also talk about the systemic factor. So if we say that grandma went to residential school, we don't assume the judge understands what residential school is. So we actually have some material about residential school. It's not our opinion about residential school. We go to those sorts of places that judges like to get information from, and lawyers like information. We go to royal commissions. We go to peer-reviewed journal articles. We can hardly wait for the TRC's final report to come out. So we put all that in so the judge can understand what these things are, to fill in those gaps. And we talk about, someone says they were adopted. We talk about the 60 scoop and the millennial scoop because we can't assume the judge knows about those things. Or the impact of childhood sexual abuse, all these things. So we talk about those things in the report. And the other thing we have to talk about, because there are two aspects to Gladue. One is, what's the circumstances of the offender? And secondly, what do we do with the person in light of their circumstances? Gladue, as the courts never tire to tell us, is not a sentencing discount case. You can't go to court and say, Your Honor, today's Wednesday, it's 50% off for Aboriginal People Day today. They have their shopper's card. They get a discount as a senior as well, if you just let them out. You can't do that. What you have to do is you have to say, here are their circumstances and here are sentencing options that may make sense in light of those circumstances. The two things have to go together. And often what also has to go together, and this is what our staff who write the reports are really good at, is engaging the individual. This isn't about just telling the person's story so people can just go, oh God, that's so awful, it's so bad, what happened? I mean, there's this sort of pornography of pain that it's not really fair to ask someone to talk about their life without having a reason for it. So the idea is to engage the person to think about their life, so that also engages them to think about what they can do, what they might want to do with their life. It's what we do for people who are not facing as serious offenses in our Aboriginal Justice Program, our Community Council Program. Engage the person in thinking about their life. What would you want to do? Do you think you have a drinking problem? No. Well, maybe after we go over, and after a while when you review the prior criminal record, what happened then? Oh, I was drinking. What happened with that when I was drinking? What happened with that when I was drinking? I don't know, you think maybe you have a drinking problem? Maybe you have a drinking problem. And, maybe people don't know. People will talk about the fact they were sexually abused when they were young. People don't say, I'd really love a program for people where deal with people who were sexually abused when they were young. Maybe they don't know that those programs exist. So it's a sharing process. It's a discussion process which helps try to move the client along as well. So that in the end, what the court's able to see is a person, understand the person's life, hear from the person and from other people. And then say, here are some options. It's not for us to pass sentence. We don't do that. Judges have to weigh deterrence, denunciation, all that stuff. We don't do that in our Gladue. It's not for us to tell the judge that he is committed to his healing. I don't know if he's committed to his healing. I can tell you that he says he's committed to his healing, and I'm prepared to say that. I can't promise that he's going to do it because I don't know. But we can provide that information. And what we found when we do that is that these sorts of reports make big differences in terms of sentence. They change Crown opinions. Crown opinions often shift. Because the Crown, you're asking Crowns to come, what's your position on sentencing? All right, I actually don't know this person at all. I just have two pieces of paper, and I'm going to pick a number 19. 19 months is my position, which is my informed position based on two pieces of paper. So, it makes as much sense as any other number. I guess they don't go back to their office and spin a wheel. But when they actually have real information about the person, then their position changes. Because the person becomes, guess what? A person. They stop being this thing where we pour our assumptions about Aboriginal people in and weigh whether or not, to what extent he or she fits those assumptions. And judges also find this to be really helpful because the person becomes a person. Many people, most people, who become involved in the criminal justice system do so because they think and they want to make a difference. Crown attorneys want to make a difference. They want to keep people safe. They're concerned about it. Defense counsel want to make sure that people are properly represented. Judges want to make sure that the sentences they come up with, because really, most criminal justice is all about sentences. As exciting as trials are, really, almost everyone's guilty, or pleads guilty. They may not be guilty, but they're going to plead. 90% of cases in Ontario that proceed to resolution are resolved by way of a guilty plea to something. And of the last 10%, 50-50 if it goes to trial. So 95% of people who have matters that eventually get decided that aren't dropped along the way, it's going to be a sentence. So the judge wants to leave thinking, I've done something. There's this word that I try, that actually doesn't really apply, frankly, sadly, that much, which is justice. We get very little justice out of the justices. There are very few people, very few days when people walk out of the court and going, we've done justice. I mean, the judges don't think that, the crowns don't think that, defense counsel doesn't think that. No one really thinks they've done a whole heck of it. Because they have so little information to work with. And so from our perspective, we find that judges and defense counsel and crowns really like having information. Not only does it make their job better, they feel better about their job. Now, our concern is not making judges feel better about their jobs. They have a lot of self-esteem, I'm sure, already. But nevertheless, our sense is that people are interested. They want to know this. And again, the biggest thing is they often don't know what they don't know. And finding ways, this is not always easy, finding ways to let people know what they don't know in a way that doesn't embarrass them. And that's why we do all our Gladue reports in writing. They're in writing, people can take them away, they can listen to them. We find it makes a difference. Gladue was decided in 1999. At the time, the Supreme Court said the overrepresentation of Aboriginal people was a crisis in the Canadian criminal justice system. The data they were relying on at the time they said that was 10 years old. They were relying on data from 1989 when they made that statement. In 1999, when they made that statement, Aboriginal people were 17% of the jail population in Canada. Aboriginal people are now over 25%. The jail population in Canada. Aboriginal women are 30%, Aboriginal youth are about 40%, Aboriginal girls are almost 50%. Situation is not getting better. It's easy to get just really bummed out and go, what the hell with it? I'm going to do something more interesting. And on a macro level, things are not going well. But on a micro level, and that's our experience, when we actually see that people are committed and are interested and want to get the information that we're able to provide, that there are differences. The differences, changes can be made. They're not made, they're made at the macro level. It's important to go to the Supreme Court, and it's fun to go to the Supreme Court if you win. It's fun to go to the Supreme Court, but that's not where everything gets done. Where change really happens is on the ground, and all of you, both in your work now, whatever that is as students, or what you're going to do when you get out, it's that work that makes the real difference. So I have some time for questions, so thank you for listening. Questions? Yes?
How do you feel that the mandatory minimums that
Well, it hasn't been good. It's been really bad. Actually, the mandatory minimums are bad. What's worse than the mandatory minimums, however, if that could be possible, what's worse than mandatory minimums is the restriction on the use of conditional sentences. So a lot of the attention has been put on the mandatory minimums, and they're not great. Although the reality with most mandatory minimums is most people were getting close to the mandatory minimum anyway. I'm not minimizing them, and we're still involved in various charter challenges to them. But what's a bigger problem is the loss of the conditional sentence. Because the conditional sentence gave judges the option to give people fairly stringent non-custodial options, and now they don't have it. So judges are often thinking, gee, what am I going to do? Is, you know, I either have to send them to jail or I have to give them just sort of probation. So that's a bigger problem. And that is a separate issue, which is a political issue, which is one that I hope people will consider when elections come. Also an issue, let me just say, also an issue that most Aboriginal political organizations do not talk about. You have very little about Aboriginal political and territorial organizations talking about justice. The last set of amendments, Sean Aplio actually spoke out against them, the mandatory minimum, but there needs to be more of that as well, because I don't think people are as aware of how significant they are. Yeah?
One of the things that I've heard is that we wanted to increase the minimum stay in prison 10 months to a year, so that people that are incarcerated can learn a skill. So what I'm trying to say is, why can't we be taking the money that's going into the prison system and giving it back into our education system? Within our First Nations communities, they're putting up prisons instead of the education. And so what we're doing is we're feeding this colonial system so it keeps on going, but we're sacrificing our Aboriginal people.
There's no question. There's no question. The average sentence in Canada is about 45 days to 60 days. That's the average sentence. People get nothing from that. People get nothing from a 10-month sentence. Frankly, people get nothing from people think, some clients think, give me a pen sentence, because I'll go to the pen and I'll learn things. You'll get nothing. For a 3-year pen sentence, certainly in Ontario, you'll get nothing. And let me just say, the one area that everyone in the criminal justice system is particularly woefully ignorant about is what happens in jail. So one of the things that we do in our Gladue reports is we talk about, here's the program, there's this program, there's that program, here's how you get them, here's what's available in the federal system, which is nothing. So we're sometimes able to adjust people's sentence within, keep people out of the pen. But you're right, it makes more sense to look at other options, because people learn a lot in jail. They just rarely learn anything that useful in a non-criminal justice related process.
They also spoke about intergenerational trauma.
Yeah.
And so now there's intergenerational incarceration.
Oh yeah. Oh, I know people who meet their dads in jail. Just as,
It's interesting about what I heard about this presentation. But the more you spoke, the more I thought, you know, things are impossible up here in Canada. I'm from Arizona. In terms of talking about change. And in the United States, you say that, you know, the way justice system is going, both of the Indian nations and the United States, and the States as well, there's a must to rethink the system. But otherwise, you're stuck in a box and continue to complain on and talk about the horrible stories. And you know, when grandfathers and grandmothers taught me that, you know, the past is the past. The only thing you can do is look at the future and make things better. And I think that's the kind of attitude maybe that should be generated among a country like Canada that's a totally unitarian system, is to open the doors to other thoughts. Seriously look at the benefit of legal pluralism. And I mean, it's something that change. Otherwise, the whole country, the whole justice system is going to explode.
no, I think you're exactly right. And one of the things that we're seeing, it's interesting. So we have these Gladue, we have these Gladue courts, Aboriginal specific courts. We have 5 of them now in Toronto. For a long time, people went, well, that's Toronto. You don't know this, but coming from Toronto is just never a good thing to be whenever you go anywhere in Canada. I am from Toronto. But the Gladue courts have now caught on in other places, and more places are bringing those courts on. And I think it's those examples When people see that there are real examples of change and they actually make a difference, then that builds up its own momentum and it gets harder and harder to stop. But your point's very important. Thank you.
We have to wrap things up. Thank you very much. We appreciate it. It was a great time.